Sorry, sir.
So with the permission of the chair, we are commencing the session. Distinguished guests on and off the dais, and my dear friends. Now this session, this is the 9th session of our International Lawyers Conference being organized by the Bar Council of India. The topic of the 9th session is evolving role of legal professionals and institutions. You know the importance of this topic, and we have very good speakers. So I'm not taking any much time. I'm straightly going on to my duties, that is to welcome the guest. His Lordship, Justice Ahsanuddin Amanullah sir, is presiding over this session. On behalf of the Bar Council of India, I extend a grand welcome to His Lordship. I also request Mr. A. Rami Reddy, BCA Trust member and Executive Chairman, to extend a bouquet as well as shawl to His Lordship. And the co-chair of the session is His Lordship Justice N. Kotiswar Singh, Chief Justice, High Court of Jammu and Kashmir and Ladakh. On behalf of all of you present and on behalf of the Bar Council of India, I extend a warm welcome to His Lordship. I also request Advocate Ramangutti, who is the senior most member of the Kerala Bar Council, to extend a bouquet, shawl and memento to His Lordship. And the other co-chair of the session is Honorable Mr. Justice Prasanna B. Varale, Chief Justice, High Court of Karnataka. On behalf of the Bar Council of India and all of you present here, I extend a warm welcome to Lordship. I also request Mr. Ranjan Kumar Shah of Bar Council of Bihar to extend a bouquet, shawl and memento to His Lordship. The keynote speaker of this session is Honorable Mr. Justice M.R. Shah, former Judge of the Supreme Court of India, and he is also the Chairman of the Legal Education Committee of the Bar Council of India. On behalf of all of you present and on behalf of the Bar Council of India, I extend a warm welcome to His Lordship, Mr. M.R. Shah. I also request Mr. Bhunesh Sharma, Co-Chairman of the Bar Council of Rajasthan, to offer. Okay. He will continue. Okay. He will continue.
Please don't disturb. यहाँ जो है ये है विभूत त्रिपाठी है विभूत त्रिपाठी विभूत प्रसाद त्रिपाठी है.
Our speaker is Mr. P.N. Shahi, Senior Advocate and Advocate General of Bihar. On behalf of all of you present here and the Bar Council of India, I extend a warm welcome to Mr. P.N. Shahi, Senior Advocate and Advocate General of Bihar. And I request Mr. Rajkumar Chauhan, Co-Chairman and Honorary Secretary of Bar Council of Punjab and Haryana, to extend a bouquet and shawl.
Two members. Two members, sir.
No, sir, no, sir. No, sir, 1 second. No, sir, please. And we have with us Honorable Mr. Vivek Tankha, Senior Advocate, Supreme Court of India and Member of Parliament, Rajya Sabha, with us. I, on behalf of the Bar Council of India and all of you present here, extend a warm welcome to Mr. Vivek Tankha. I also request Mr. Prasanna Kumar Pahi, Member, Orissa Bar Council, to come and extend a bouquet, shawl, and memento to Mr. Vivek Tankha. And we have with us Mr. Lalit Bhasin, Senior Advocate, Supreme Court of India, and on behalf of the Bar Council of India and all of you present here, I extend a warm welcome to Mr. Lalit Bhasin, and I request Mr. Suvir Sidhu, former Chairman of Bar Council of Punjab and Haryana, to offer bouquet, shawl, and memento to Mr. Lalit Bhasin. And we have also with us Mr. Mohit Saraf, Senior Advocate, and on behalf of the Bar Council of India and all of you present here, I extend a warm welcome to Mr. Mohit Saraf, and I request Mr. Tripathi of Orissa Bar Council to come and offer bouquet, shawl, and memento to Mr. Mohit Saraf. And I welcome each one of you present here, and I hand over the session to Mr. Justice Ahsanuddin Amanullah, Chairman of the session. Thank you, sir. Thank you very much.
A very good morning to everybody. I hope everybody is comfortable if we sit here and talk. Is it okay with all of you? It'll be easier because coming out and going will again take some more time. Welcome everybody. Honorable Mr. Justice M.R. Shah, distinguished former Judge of the Supreme Court and Chairman Legal Education Committee of the Bar Council of India, Justice Prasanna B. Varale, Honorable the Chief Justice, Karnataka High Court, Justice N. Kotiswar Singh, Honorable the Chief Justice, High Court of Jammu and Kashmir and Ladakh, Mr. Vivek Tankha, Lalit Senior Counsel and Member of Parliament, Mr. Shahi, representing Mr. Prashant Kumar Shahi, the learned Advocate General for Bihar, Dr. Lalit Bhasin, President, Society of Indian Law Firms, Shri Mohit Saraf, Founder and Managing Partner, Saraf and Partners, functionaries of the Bar Council of India, various state bar councils, dignitaries, lawyers, law students, guests of the dais. A very warm welcome. At the outset, I congratulate the Bar Council of India, the Law Society of England and Wales, the Bar Council of England and Wales, and the Commonwealth Lawyers Association of having chosen for technical session number 9 the topic Evolving Role of Legal Professionals in Institutions. As we are all aware, the legal sphere is in the throes of a tectonic shift. Be it artificial intelligence or globalization, there is no such thing as constant and fixed. Every day, do you have a mic?
I think this one is the one. I think that mic is not good.
Oh no, you must be having some. For the speakers, do you have a mic? Oh, okay, now it's better. As we are all aware, the legal sphere is in the throes of a tectonic shift. Be it artificial intelligence or globalization, there is no such thing as constant and fixed. Every day brings onto stage one or the other issue to which no easy solution seems forthcoming. I must confess that my view on the theme is itself evolving. Broadly speaking, one may endeavor to group legal professionals into few categories. First, lawyers practicing independently. Second, lawyers working as part of a firm. And thirdly, lawyers working in-house. Likewise, in terms of legal institutions, one possibly may label them into A, statutory bodies like the bar councils, national and state, B, representative bar bodies such as the bar associations, national, state, district, et al. And finally, interest-specific groups such as society which Dr. Bhasin heads. Of course, the above is only a rudimentary sketch, and as this session proceeds, I hope we will all have a better idea on a role that suits what the future envisions. The importance of the different types of lawyers and types of institutions cannot be overemphasized. The significance of polyvocalism in courts, as highlighted even yesterday by Honorable the Chief Justice of India, does not confine itself inside the courtroom, but stretches outside, where lawyers are not just lawyers, but those who influence public opinion, impact policy and drive change. Purely as food for thought, one may ask, what should the Bar Council do in the face of, say, a call for a strike or cessation of work by a bar association? With learned Justice Shah in the case of Ishwar Shandilya, I had an occasion to explore the issue and hence would say no further. Let us take another example. Assume members of the bar have a genuine grievance against a learned judicial officer. What ought to be the position a bar council or an association should take? As I stated earlier, these are questions to which there exist no easy answers. Add to this the constant cover of the media. Every move is questioned and judged. Adding to the significance of the theme, what should legal professionals and institutions do when confronted with these? What is to be the future of legal education in India and around the globe? Yet another example, when lawyers say they will deny their services as a collective to someone accused of a heinous crime, what does the legal profession do? While looking to pigeonhole answers and responses and choices into right and wrong, what we sometimes forget is not just that not everything can be so classified, but at the end of the day, who can classify them? As women and men of the law, whilst in law school, a lot of us carry the impression that the law is either black or white, but once you step into the profession, you realize that shades of grey exist and persist within the confines of law itself. I may formally be the chair of the session, but I am looking forward to hearing what the others have to say. Brothers Varale and Singh are heading the high courts, and I am sure they will have experiences to share as to how certain institutions' responses can be uniform across the country, whereas certain others may require regional tweaking. Mr. Tankha and Mr. Shahi bring, if I may say so, a unique blend of the legislature and the law to the table. Both have served or are serving as top law officers of the states. Mr. Tankha also has been for the union, while Mr. Shahi has been part of the Bihar cabinet. Dr. Bhasin has been representing the cause of Indian law firms, and Mr. Saraf leads a firm straddling diverse areas of practice. Honorable Justice M.R. Shah was my Chief Justice at the Patna High Court, and I have been able to discern, albeit in his Lordship's short tenure there, his knack and commitment to solving problems and revitalizing existing systems. With him at the helm of the Legal Education Committee, I am sure that in the times to come, the profession need not be unduly worried about the standards of legal education, which will definitely be on an upswing. With his vast experience of dispensing justice as lawyer, High Court Judge, Chief Justice and Supreme Court Judge, I am also waiting for bated breath to hear his keynote address. Before concluding, I would like to leave the audience with one thought, which in my view should be the seminal note on which a lawyer's day must begin and end. Injustice anywhere is a threat to justice everywhere. Jai Hind, thank you. Now I would request Honorable Justice Prasanna B. Varale, Chief Justice, Karnataka High Court, to just address. Yes. He has become wiser that my voice probably could not carry. He wants everybody to hear what he says.
Good afternoon to you all. Respected Chair, Honorable Shri Justice Amanullah sir, Shri Shah sir, my esteemed brother Kotiswar Singh sir, the panelists, the young students, the representatives of the bar councils, coming from the different state, the representatives of the Bar Council of India, young students. So before I proceed to my speech, with your permission, I may share one or two things. I was really very happy to see Saraf is also one of the panelists, and the reason for that I may share with the young students that Mr. Saraf, apart from his contribution to law field, is a recipient of Shaurya Chakra for his peaceful active involvement at the hands of our former president, Sri Venkatraman. Sir, I congratulate and thank Bar Council of India for arranging this grand conference and giving us an opportunity to share our views and also to hear the views of the legal luminaries. Sir, when you are in presence of legal luminaries and share the views or hear the views, a feeling for me, who comes from state of Maharashtra, and some of the young members of the Bar Council of Maharashtra and Goa are here, I be allowed to refer to Abhanga of our Sant Jnaneshwarji, and it goes like, Are are ज्ञाना झालासी पावन, दीपकी दीपक उजळल्या ज्योती, घर वाती शून्य झाल्या. Meaning thereby, when one lamp of knowledge lightens up other lamp of knowledge, there is no need to have any external source of knowledge when the source of knowledge is here and around you. The legal profession, once characterized by its traditional practices and conservative approach, is undergoing a profound transformation in the 21st century. This transformation is driven by a confluence of factors, including technological innovations, shifting of societal values, globalization, and changing dynamics of the legal marketplace. It is imperative to delve into the multifaceted evolution of legal professionals and the institutions that sustain and shape their roles in contemporary society. The transformative shift was underscored by the judgment of the Honorable the Apex Court in the case of Puttaswamy versus Union of India. The legal tech startups like Vakil Search in India have emerged, and other platforms like SSC Online, Indian Kanun, Live Law, Bar and Bench, etc., have made legal service more accessible to a wider population. Such initiatives not only exemplify the changing role of legal professionals, but also underscore the importance of leveraging technology to bridge the justice gap. The digital age has ushered in a technological revolution that it revolutionizing the practice of law. Legal professionals and institutes are harnessing the power of artificial intelligence, machine learning, and data analytics to streamline their process. The destructive impact of COVID-19 pandemic served as a prominent example. Beyond its effect to access to justice, it has underscored the vital role of technology for legal professionals. The initiative it sparked is now being further developed and expanded by the Honorable Apex Court and various high courts. Access to justice is a fundamental right for every citizen, and preparing for potential future disruptions through the digitization of court record, the adoption of online dispute resolution mechanism, etc., is imperative. This not only enhances efficiency, but also improves the quality of legal service. Contract analysis, predictive legal research, and e-discovery tools are just a few examples of how technology is redefining the role of lawyers. However, this transformation raises ethical questions about the responsible use of artificial intelligence, data privacy, and the potential for job displacement. The legal profession's duty to ensure justice for all is more critical than ever, and technology plays a pivotal role in this pursuit. Online dispute resolution platforms, virtual court proceedings, and legal tech startups are making justice more accessible, especially for underserved population. Yet, challenges related to cybersecurity, data privacy, and digital divide persists. The several initiatives have been taken to improve the access to justice, such as National Judicial Data Grid, Case Information Software Justice App for Judges, court hearing through video conferencing, live streaming of court proceedings, new e-filing system, Telelaw mobile app, national service, and tracking of electronic process and step for technology-enabled process, serving and issuing of summonses. The evolving role of legal professionals and institutions involves not only embracing these technologies, but also addressing the disparities they may create. In a world where borders are increasingly porous, legal professionals are grappling with international legal complexities. The globalization of business, coupled with the ease of digital communication, requires lawyers to navigate an intricate web of international laws and treaties. Legal institutions must adapt by providing guidance on cross-border legal matters and fostering a globalized perspective within the legal profession. As legal professionals embrace technological advancements and grapple with global issues, ethical considerations become increasingly complex. It is important to examine how the evolving role of legal professionals and institutions necessitates ongoing reflection on ethical dilemmas such as AI bias, data ethics, and maintaining the public trust. Legal institutions are recognizing the critical importance of diversity and inclusion. The evolving role of legal professionals involve championing diversity with profession itself and in pursuit of justice. Diverse perspectives enrich the legal discourses and help ensure equitable outcome. The evolving roles of legal professionals in India are deeply intertwined with shifting societal norms. The Indian legal system has evolved to reflect societal changes such as decriminalization of homosexuality in the case of Singh versus Union of India. This landmark judgment of Honorable Supreme Court was a testament to evolving role of judiciary in adapting to and endorsing progressive societal values. The legal profession must continue to champion the inclusivity, a value deeply embedded in the Indian constitutions. The words of Dr. Babasaheb Bhimrao Ambedkar, the principal architect of Indian constitution, resonate in this context. We are Indians firstly and lastly. Legal professionals must take up the mantle of ensuring that the law serves as an instrument of change in fostering a more inclusive society. To meet the demands of an ever-evolving legal landscape, institutions responsible for legal education and training must adapt their programs. Continuous learning, interdisciplinary skills, and adaptability are becoming prerequisites for legal professionals. Legal education must equip lawyers with the skills to navigate technologies, ethical and global challenges. Moreover, the institutions should provide ongoing professional development opportunities to help lawyers stay at the forefront of the field. Technology integration, practical skills training, and experimental training, interdisciplinary studies, clinical education, innovation in legal technology are some aspects that legal educational institutions must focus on in a rapidly evolving legal world. The evolving role of legal professionals and institutions is a dynamic and multifaceted phenomena that touches every aspect of our society. Legal professionals are no longer confined to courtrooms and law offices. They are leaders in digital and global age, shaping the future of justice, ethics, and society itself. Embracing change, upholding ethics, ensuring access to justice, and promoting diversity and inclusion remain central to the mission of legal professionals and the institutions that support and guide them. As we navigate the ever-changing currents of the legal profession, it is our duty to ensure a shared commitment to justice, ethics, and betterment of society. With these words, thanking the dais, the Honorable Chair, I take your leave. Thank you.
Now, after hearing Justice Varale, I think he's also set some sort of a tone. How professional are we to get for the future? It looks like a daunting task, but I think we have already begun on that path, and there's now no turning back, especially after COVID. So we just have to take the movement forward. Now I request Honorable Justice Kotiswar Singh to share his views with us.
Good afternoon to everybody present here, the Honorable Chair, Justice Amanullah, Honorable Justice Shah, keynote speaker today, and Brother Varale, and other eminent speakers, members of the Bar Council of the various states, the students, ladies and gentlemen. Yes, I'll be continuing something which have been already spoken in the first session today. The legal profession in this country has its roots in the colonial era. During this period, the British colonial rulers imposed the legal systems and jurisprudence on us. Proficiency in law was a specialized discipline, and access to legal education was limited to privileged classes. This exclusivity made the legal profession a preserve of the elite, and only those with rich background and recommendations from England or a judge in India could be permitted to practice in the high courts of the three charter institutions. The legal profession, by its very nature, has an inquisitive mindset and a propensity to question the status quo. This inherent quality of the legal professionals played a very vital role in fostering nationalism and political awakening in India. As lawyers delved deeper into the intricacies of the colonial rule, they began to question the prevailing conditions, including the unjustness of the colonial policies. This probing attitude among the legal professionals sowed the seeds of dissent and paved the way for the active involvement in nationalist movements and fight for India's freedom struggle. I do not go in detail of the freedom struggle. We have these famous personalities, Umesh Chandra Banerjee, Badruddin Taibji, Sir, Firoz Shah Mehta. They were the leading fingers of this when the Indian National Congress was formed for the first time. I will not go. Punjab Kesari, we have Lala Rajpath Rai. He himself was a founder of the Bar Council of Hisar. And he had a very multifaceted personality. He was involved also in, he founded this Punjab National Bank and attended many international labor conferences. In fact, he presided over the first of All India Trade Union Congress. These are we have the very rich pedigrees. Now, India's journey towards independence culminated in 1947, and the task of framing the constitution fell on these visionaries. Out of 389 members of the Indian Constituent Assembly, as many as there were 250 lawyers. Just see the contribution of this profession. This contribution in nation building of this pre-independence era continued after the independence. Some of the sharpest minds in the legal profession in India have assisted Indian judiciary in broadening the vistas of the concept of equality, justice, and liberty. Some of the famous cases we remember, Menka Gandhi's case, passport case. We remember Bandhwa Mukti Morcha case. We remember Keswananda Bharati case, just to highlight some of these important judgments which are rendered with assistance of some of the brilliant lawyers with vision. Therefore, this legal profession has helped in broadening the vistas of concept equality, justice and liberty having universal applications, and help chart a new legal pathways like the public interest litigation to make human rights more meaningful and realistic in the context of a functional democracy like ours, and to make access to justice a reality for millions who have remained on the fringe of the society. The legality of the basic structure of a constitution, which is now firmly entrenched in our legal system, has ensured continuity of our democratic values and institutions without abrupt disruptions, in which some of the best legal minds have played a significant role. In short, I would say the legal profession has played a stellar role in transformation and development of society and stabilizing it on the basis of the concept of rule of law. Now, one of the most challenging tasks before the legal fraternity is how to make ourselves relevant to the last sections of the society, the weaker sections, the marginalized. Legal aid, which is a part of the directive principles of state policy, is considered to be part of Article 21, right to life. To make right to life meaningful to the unprivileged by providing legal aid assumes great importance, in which the legal fraternity must play a more proactive role. There are about 6 lakhs of prisoners in India, and about 77% are under trials, and many of them are in overcrowded jails. As per the World Bank report, in 2022, about 10% of the population are still poverty line, below poverty line. There are about 23% of the population are still illiterate. Though there has been a sharp decline in the child marriages from 37% in 2006 to 16% in 2021, still a big problem. There are about 22.8 lakh crime against women recorded during this 2016 to 21. If legal fraternity has played a significant role in the pre-independence, today the legal fraternity must play a more constructive role in bringing about a more equitable society, and must join in the campaign against poverty, illiteracy, corruption, terrorism, and decisive forces which are eating into the vitals of our democracy. Thus, the need of the day of the legal profession is to change the focus from a private-oriented profession to a public-spirited, driven legal profession. Adversarial litigation has been a mainstay of our justice delivery system in our country. The training, the habits, the practices, and resultantly the mindset of the legal profession are geared according to this approach of adversarial litigation. However, because of increasing number of cases, resulting in huge pendency of cases, causing undue delay and disposal of cases, justice has been literally rendered elusive and illusory to many. As of today, as I stand today, there are more than 1 crore 10 lakhs 86,000 civil cases pending over the whole country. There are more than 3 crores 33 lakhs 72,000 criminal cases pending all over this country. 4 crores and 44 lakhs cases, huge number in this country of 140 crores. And this shows that 10% of our population are stuck in litigation. It's a big challenge before us. Now, this has necessitated changes in the system. We have seen the introduction of this alternative dispute resolution mechanism by incorporating Section 89 of CPC, which casts a responsibility to the court to see that cases which can be disposed of by settlement can be done at that earlier stage. Some of the other ADR mechanism, which has become very popular in India, become part of the statute, is also the holding of Lok Adalats, in which a number of cases are being disposed of. Yes, we also see the development of mediation with this introduction of the Mediation Act of 2023, which requires a change in the minds of the lawyers. As I mentioned, adversarial system makes us the minds are trained to defeat our adversary. But this mediation, we have to change to a conciliatory approach to create a win-win situation for both the adversaries in a most amiable and conducive atmosphere. This is a big change required in the mindset and training of the lawyers. This is, I feel, a very important evolving role of the lawyers. There is, of course, another aspect in which area has been also introduced. The arbitration, His Lordship has been an expert in the arbitration matters, has delivered a number of landmark decisions. How to reduce this huge, the pendency of this court, unburdened from the system, in which the role of the lawyers continue to be important. The role of the judges are reduced, but not of the lawyers. It continues in a different, more conciliatory form. And I can say also that normally we think that when we appoint arbitrator, we appoint retired judges. But I have seen from my experience that lawyers themselves say, no, please appoint this lawyer also. Therefore, lawyers, you should also think yourself also a possible potential arbitrator, for which obviously, of course, you have to have a good reputation in the eyes of the public as well as the bar. This is also another aspect which needs to be underscored as far as the evolving role of the lawyers are concerned. Yes, this itself means that we have to have a very universalist outlook. Confined, see, we can't remain confined to court-centric approach. We have to have this universalist outlook, for which we need to understand the laws of the different countries. We have to learn the different numerous international covenants, international instruments, which are equally applicable to this country. There is another area which I want to flag, these issues about the environmental law. Lawyers can play a very, very important role. If you check up the Supreme Court website, you will see 348 cases reported, filed by M.C. Mehta, who has brought in huge revolutionary concepts and ideas in this country as far as the environment law is concerned. India has been ranked 63rd among the 190 countries in the ease of doing business in 2023 of the report of the World Bank. This has been possible because the ambitious program of regulatory reforms launched by the government of India for making it easier to do business in India. And remember, India was the third worst in resolving commercial disputes as per the World Bank report in 2013. What a dramatic change. All this happened because of very innovative changes which have been brought in our legal system with the introduction of these commercial laws, and of course with the introduction of this Mediation Law Act in 2023, we are going to see a sea change. I think it's going to be a game changer if we are able to implement this act in the proper spirit in which it is made. And in this case also, the lawyers have been given a very, very important role of mediators. Therefore, lawyers need not be adversarial all this while it may be a mediator, a conciliatory approach. So these are evolving scenario in Indian legal system. There's another catalyst to this doing this business. Here, the role played by NJDG, which has been in operation since 2015, is enormous, which has made our working system in the court much more transparent. Today, on a click of a button, you can see what is happening in your case without even visiting the court physically. Changes are taking place. Brother Varale also mentioned about the digital ecosystem which have been introduced. I will not speak about it, but is a fact, is a reality, that today's Indian legal system, lawyers, legal professionals are not really fully equipped, except for those lawyers who are in the cosmopolitan cities, big cities. When I go down to the districts, when I go down to taluks, there are problems there. But with the same statutes, with the same aim in the profession, there's a big divide, digital divide amongst the lawyers. This is the challenge which we have to address. There are, of course, today's laws are become much more specialized, much more complex, because the boundaries are also mentioned earlier by the speaker is becoming blurred. The result is that we have to reach out to other disciplines of life. We have to be sociologists, we have to be anthropologists, we have to be economists, not merely confined to our CPC, CRPC Evidence Act. There has to be a much more broader understanding of how society works, not only in this country, but other neighboring countries, other parts of the world. It is very, very important that we broaden our outlook, our understanding of law. Yes, in that context, this collaboration with legal professionals from other countries become very, very important. Opening of foreign firms, even if for a limited purpose and scope, has huge implications, which will open up this collaboration, understanding of their laws, which are becoming equally applicable to us also. I have spoken about this fraternity, but what about the Bar Council of India, which is the apex body governing this legal profession? They have to change their outlook also. Bar Council has a huge responsibility to reaching out to the members of the bar in the talukas, in the districts. India is a huge country, multiple cultures, languages, traditions, and to have a common view. In fact, I consider Indian legal system to be one of the most important cementing force of this country. We follow the similar principles of law. I am from Manipur. I go to Kashmir. I have no problem dealing with law. If I am transferred tomorrow to Kerala, I won't have more problem except for perhaps the local laws, because we are bound by the same common principles of law, guided by the same preamblic vision, the principles laid in our constitution. Yes, I see a vast disparity among the lawyers. Much has been spoken in the earlier session. Things need to be done, examined by the Bar Council. In conclusion, I can say the legal profession in India has played a multifaceted role fighting for independence to nation building. It continues to play a vital role in shaping our development, reaffirming democratic values, and upholding rule of law. India is an emerging power in the international arena, thus building a robust legal system in tune with the international norms and requirements is a sine qua non to retain the prominent place in the Committee of Nations, in which the legal profession has to play a significant role, and I believe this conference will help our legal fraternity fine-tune their unique role and responsibility. I know nowadays Charles Darwin is discredited in many circles, but I cannot but quote him as I end my address. It is not the strongest of the species that survives, nor the most intelligent that survives. It is the one that is most adaptable to change. Thank you. Jai Hind.
Thank you, Brother Kotiswar. I think he has made a lot of strong emotive points. I think a lot of people must ponder on that. It doesn't need reiteration, especially your role how to connect to the people and deliver at the grassroots. I think we'll follow it up as the session progresses. But now I'd like to welcome and request Honorable Justice M.R. Shah to deliver his keynote address. Sir.
Good afternoon to all of you. I esteem earlier colleague Justice Amanullah, Judge Supreme Court of Senior Advocate and Rajya Sabha member Sri Vivek Tankha, Senior Advocate and Advocate General of Bihar Sri Shahi, Senior Advocate Sri Lalit Bhasin, and my dear friend Mohit Saraf, Sri Manan, other office bearers of the Bar Council of India, distinguished participants present who have come from various parts of the country, my dear students, friends, ladies and gentlemen. First of all, I am thankful to Sri Kumar Mishra and his colleagues for giving me this opportunity to be here and to speak on a very important subject. I also congratulate the Bar Council of India for organizing such an important international lawyers conference, of which very important and interesting subjects, namely emerging challenges in justice delivery system, which is in fact is the need of the day. I congratulate the participants, Bar Council of England and Wales, the Law of Society of England and Wales, as well as Commonwealth Lawyers Association for their participation. My earlier speakers, more particularly two earlier speakers, have spoken on the subject very in detail. But I have to perform my duty also. The subject is evolving roles of legal professionals and legal institutions. In a democratic country, to meet the challenges of the legal knowledge needs of the 21st century, legal education must conform to the ideas of innovation, information sharing, knowledge application, and its management at the professional and institutional levels. Legal education is known to be inclusive of knowledge, faculties of all the multidisciplinary fields of the education, and its correlation with other subjects to make more relevant to meet the practical and professional needs. The last century was dominated by traditional methods of imparting education, where classroom learning and training was tremendously emphasized upon. With the modulations in the methodology, with case studies gaining importance, practical skills and learning started becoming the order of the day. With the limited applicability of case methods and studies, legal clinics came into existence to provide and assist the people in seeking justice. Public trust and morality need to be fueled with esteemed principles. The legal education carries the weight on its shoulders of creating responsible citizens in the country, which are the major catalysts for delivering democratic ethos through social justice, political and economic welfare. A balanced approach between legal education and legal profession shall pave the way for a just and economical society.
power and weaker sections should be able to seek justice, keep morals and discipline intact. Legal education has significant role to be played. The legal education does not aim to bind itself to the making of legal academicians and legal professionals. Instead, it serves the wider audience by making people aware of the rights and duties. Thus, a strong knowledge base is of utmost importance in understanding the legal world. When we talk about the legal institutions, what do you mean by institution? Institution is not a place and or college where only the advocates or the lawyers are prepared or manufactured. Institution is a place where the legal professionals are created. Therefore, the institutions imparting legal education who ultimately create and or prepare professionals play a very important role. There is a heavy burden on the shoulders of the institution to impart qualitative legal education. The quality of their education today will raise the competence of the nation's legal profession tomorrow. In view of the changed scenario, the challenges are more, and the law institutions have to provide qualitative education, which can only be where faculty and the professors are qualitative. Good and ethical professionals come from the good institutions, and therefore, what is required is the good, responsible institutions. It is the need of the day to provide quality legal education. Only good infrastructure will not provide quality legal education. A good teaching staff, faculty is required for that. Good institutions should not be considered as a source of income. To maintain the rule of law and harmony among the people and to protect the human rights and to serve the common man, legal professionals play a very important role. Due to importance of the lawyers, they are called professionals. Good professionals come from good institutions. If we consider the history, it can be seen that the legal professionals in the past have played a very important role in the society, more particularly for upliftment of the common man and to protect the human rights. The legal professionals have played a very important role in building our nation. They have played a very important role even in the world. The history, Justice Kotiswar have already said that what role was played by the lawyers or the legal professionals in building our nation. But so far the legal professionals are concerned, a day has come now to change. These are the days of transformation. We are changing from adversarial legal system to digitalization. We are changing from the courtroom dialogues and the courtroom matters to be decided to arbitration, mediation, conciliation. The role of the legal profession is now not restricted to only the traditional litigation and the traditional methods. In the commercial litigation, they can be mediators also, they can be conciliators also, they can be the arbitrators also. When Justice Kotiswar Singh that advocate, but I have seen in Bombay, correct, more than 50% arbitrators are lawyers, and even youngsters also, they become the arbitrators, and successfully they are performing their duties as an arbitrator. So, legal professionals, they have to change themselves now. now where we are talking about, now the permission is also granted to foreign law firms to come come and practice in our country also. We have to compete with those persons. And as we have to compete with those persons, we have to change our system. We have to change our methods. The traditional, you see, Vakil Sahib is changed now to lawyers and advocates and the mediators and conciliars. But I must say, and always I emphasize, that in the earlier days, when the legal professionals were called Vakil Sahib, the values and the respect which was given to the lawyers and the Vakil Sahib, correct, those have gone down. It may be true that due to falling down the values and the ethics, overall image of the legal professions has gone down. Those traditional lawyers who were passing in the market, where Vakil Sahib has come, see the respect which was given to this legal profession, Vakil Sahib. In every thing, Vakil Sahib was there. But the situation is not so bad. Every legal institution shall have to see that a good legal professionals are prepared so that they can serve the nation better like earlier times. When Justice Kotiswar Singh has said about the role of the Bar Council of India, I would also like to say something. As a part of the Bar Council of India, as a chairman of the Legal Education Committee on that also, I consider Bar Council of India as also institution itself. The Bar Council of India is as such committed to provide quality education, and therefore strict norms are being followed while granting even recognition. The emphasis is not on quantitative institutions, but the qualitative institutions. Strict discipline is expected of the legal professionals. I congratulate the Bar Council of India for selecting such an important subject. But because of the change of time and the transportation, globalization, everything, now we have to change from traditional subjects and traditional education, legal education, to the new legal education. We have to, a day has now come when we want to compete with foreigners, foreign law firms and foreign advocates. We have to change the even curriculum also. A day has come now to change the curriculum, as rightly said, from CPC, CRPC, Evidence Act, we have to change to the commercial laws. We have to change with the practice also. We have to change with the technicalities also. We have to change how to address and mention, argue in the courtroom also, because of the digitalization, etc. Bar Council of India is committed for that. In earlier days, anybody who was passing the LLB examination was becoming the lawyer. But to see that there is the quality legal professionals are there, the examination for advocates was introduced by the Bar Council of India. And that is why, with that purpose of qualitative legal professionals, the Bar Council of India came out with the advocates examination. This was the first step towards the qualitative legal professionals, who play a very important role in building the nation, and nation not only, but in the economy of the country also. I, as a chairman of the Bar Council, chairman of the Legal Education Committee, assure that radical changes, we are going to do it. We will propose, we may change the curriculum also, we may change the methods also. Give us some time and we will be able to do it. And Bar Council of India who is committed for a qualitative better education, legal education, and the legal professionals will do it and perform its duty as a parent institution for so far as the legal profession is concerned. I am thankful to Justice Amanullah, who is chairing the session, for giving me this opportunity. I am not saying more because my earlier speakers, all the three speakers have said, but still, correct, I emphasize on the change, importance of the role of the legal professionals and the institutions. I emphasize that the institutions is not to be considered as a source of the income only. Institutions have also to change, legal professionals have to be changed. Legal professionals are part of the society and they owe duty to the society also by doing work to maintain for the upliftment of the rule of law, human rights, common men, because legal professionals are part of the society and they owe duty to the society and common men. And I am sure the legal professionals will not be confined only now to the courtroom only. I wish all the success to this conference, and I am sure that whatever will be is discussed and will be discussed in the conference will help in ultimate achieving the goal of good, ethical, qualitative legal professionals. Once again, I am thankful to the Bar Council of India for giving me this opportunity to speak on the occasion. And the subject is at my heart as chairman of the Legal Education Committee of the Bar Council of India. I assure on behalf of the Bar Council of India to provide qualitative and ethical legal education in the country and to establish the institutions who will create good legal professionals to serve the human being and the common man. Thank you very much. Jai Hind.
Thank you, Justice Shah. I think with a person like him giving a commitment from this open platform, I think we can really expect results soon and positive results. I know how his lordship feels. I've had the good fortune of sitting with him, sharing the bench and discussing many things. And the ideas he carries, and he knows how to get things implemented also. So that's the biggest difficulty. You may have ideas, but how to implement, he has this neck, and it has given me also a lot of hope for the future from BCI. Thank you, sir, so much. Now, I would request Mr. Vivek Tankha, Lalit, Senior Counsel, to just share his views with us. I think we'll have to spill a little bit over to the lunch session, but I think at the end you will find, no, I'm telling them, the audience, at the end you will think that it was worth missing that 15 minutes. But the speaker still to come.
Sir, we'll still assist you by making it short, sir.
Thank you so much.
So that people have to
This
leave.
is a good lawyer. He takes the hint very fast.
We get this lesson all the time, whether we are in court or in parliament. Sir, with cutting it very short, addressing the learned dais and the learned participants here, without even taking names to make it shorter, I would say that today it was a very impressive day when we heard Justice Kotiswar Singh, Justice Varale, and then Justice Shah. I must tell you, when he spoke about legal education, it is something which we are also engrossed at in the Parliament. I'm in the Committee for DOPT, Law and Justice for many years. Mr. Manan Mishra with his entire team has come to us many times with the Secretary Justice and all other functionaries. And yes, it's time for change. If India needs to change, the law needs to evolve. If we don't evolve our law, if we don't change our patterns, if we don't change our systems, we'll be left behind. So I completely endorse what has been said by the previous speakers, and there's nothing to add. But I must also say something with Justice Amanullah mentioned, sir, about strikes. This is my view, sir. I was in Parliament last week, and one day, because of the situation, I never enter the well, because I feel it's wrong to enter the well. We parliamentarians are there to debate and not to enter the well. But one day, my whole party and the whole opposition, for some reason, decided to enter the well, and I was like pushed into the well. The Vice President looked at me and he says, no, 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 you couldn't have come. I don't mind others. How are you inside? How can a man who's respected for his legal, in the legal fraternity as a man of law, how can he enter the well? I felt very sheepish also. And then a few days later, when the Parliament finishes, the Vice President gives the final address. I was not there, but he took my name. And he said, I was shocked when such and such person, a parliamentarian, entered the well. And we look at him as an icon. People in Madhya Pradesh follow him. And how could he be doing a wrong thing? I wrote a long letter to him. And then one day in Parliament, I got my opportunity. This is last week. And I told him, I said, sir, the problem is not that we should not enter the well. Of course we should not enter the well. But the problem is also that why are we entering the well? Because your systems do not permit the opposition to get their space. Give them their space, they will not enter the well. And I gave him 3 examples. In the House of Commons, this used to happen very often. So one day now, every week is given to the opposition to set the agenda. It's the opposition which decides what should be discussed. Suppose I wanted, I'm just giving an example. We wanted a discussion on Manipur the whole of last Parliament. We couldn't get it. We moved adjournment motions, we couldn't get it. But if we had the right of one day, it would have happened. And that would have, the steam would have passed off. Number 2, I said, if every day 50 adjournment motions are given by 50 lawyers and they are rejected, I said, it's belittling. Now, if I enter the well, you should feel that also how belittled we must be feeling that our request is not being met. We are 50 responsible people, and what are we wanting? A discussion. And how can a discussion not be allowed? I gave him 3 such points. And another was which is not in India so far. I said, there should be a system in this country now. If you want to change, if you want to make it more democratic, a special session of a parliament can only be requisitioned if government wants it in India. That's our constitution. But I said, sir, it's time, if 30% of MPs of a parliament want a discussion or a session for a subject, you should summon it. I said, you have to evolve it if you want to strengthen the democracy, if you want to strengthen the institutions, all this must happen. Everybody clapped, of course, and they said he said the right things. Why I'm saying this is, sir, by writing judgments, the strikes are not going to stop. Your stakeholders are lawyers. Please involve them more in your decision-making processes. The moment you make them responsible for your decision-making processes, the strikes will stop. I have tremendous confidence and respect for this fraternity of law. 80 to 90% of lawyers would never want to go for on a strike, sir. It's only a fringe which pushes you for a strike. But that fringe can be isolated the moment we become stakeholders in a system. And that is what not only applies for court, it applies for the country. If you want India to be peaceful, if you want peace in Kashmir, in Northeast, in South, in West, wherever, you have to make people of each area stakeholders of their lives. If you make them stakeholders of their lives, obviously you will find that they would not be indulging in things which we perceive as incorrect or irrational or violating our norms. So the point that I'm making, sir, look at this huge issue of strike. If we only think that passing judgments, we can stop the strikes, it has not happened. Supreme Court has passed so many judgments on this issue, sir. But these strikes happen because of sometimes incorrectly, sometimes irrationally, but sometimes they are justified also. So if you make the system more participative, I think the things will change. Another thing I want to say that there are two eras of lawyering, the pre and the post constitution. Pre-constitution, we didn't have a constitution. There was a justice edifice, and in that justice edifice, justice would take place. Post-constitution, we have a people's edifice. People have rights. People have duties. People can approach to court, and a citizen has been empowered, in fact. The Constitution empowers the citizen to enforce his rights, to protect his rights, sir. And believe me, you are the protectors of the rights of people, while lawyers, I say, are soldiers of democracy. So if the soldiers of democracy and the protectors of rights of people come together in unison, I don't think anybody can take this country astray. Your Bar Council has a very big role to play, whether it be legal education, whether it be discipline, whether it be selection process, everywhere. It has a very, very big role to play, which, yes, you are right, sir, they have not been playing. In fact, post Bar Council, the disciplinary actions, frankly speaking, I feel, are abysmally low. Now that I find in Parliament also. People use such abusive words inside Parliament and they get away. How can you be rude? How can you be intemperate? How can you be wrong and get away, sir? What I'm trying to just say at the end is, this society needs to have its sense of justice in place. You need to have your sense of justice in place. You can't be partisan in your sense of justice. If you're fair, if you are just, I'm sure the society or any institution would work correctly and will be on the right path. So with this little summation, I would only say that I'm grateful that I was asked to come here and speak on a topic which I say is called justice. And justice is the oldest concept of the world. It was a concept which even kings followed. It was a concept which even the crown followed. It was a concept which was evolved by courts. It's a concept which has been developed by the Constitution. It's a concept which is dear to our heart. And without justice and without a Constitution which gives justice to us, there is no life. And if there is no life, I feel there is no human rights. And if there are no human rights, then we are not living in a civilized world. Thank you. Jai Hind.
Thank you, Mr. Vivek. That was a very spirited talk from you. Just one caveat. The strikes which I alluded to was not the bar and bench related. It was because recently, I will not take the name, for 5-7 days there was a strike for an incident which happened totally outside, nothing to do with the bar and the bench. We are totally not on those strikes. I am referring to those because you have a responsibility towards your client. You have to understand who loses ultimately in this backlog. In that context, it's just a thought for consumption. It was not that the courts are trying to interfere or passing judgment. Nothing to do with that. Absolutely not even a comment on that. Only because unnecessary for 3-4 days, the whole entire one province was on strike, and the litigants all, backlog out. In that context, just a thought for consideration. And I'm very glad to hear that still there are fires in the legal profession to uphold democracy and the rule of law. It's so encouraging. I keep on telling in every forum that we have to stand up. Your place has been taken away. You have to get back your place. And that is by standing up for the right cause. You cannot have a cause in your heart and keep silent. It is not permissible. You are not allowed. That excuse is not available to us. And so thankful to Mr. Vivek for setting that tone. Thank you so much. Now I would request Mr. Dr. Lalit Bhasin to kindly share his views.
Thank you, Honorable Chair, and all the eminent judges, my colleagues from the profession. The topic is evolving role of legal professionals and institutions. I have seen the evolution because I think I must be, if I can say with some daring certainty here, I must be the oldest practitioner of law present in this. I started my law practice in 1962 and I have seen myself the evolution of law, the evolution of the judicial processes, the rise and fall and rise of the legal profession. I have also been a part of the institutions, being the oldest living chairman of the Bar Council from 1973 to 77. I have held positions in the profession, still holding, as the immediate past president of the Bar Association of India, and currently the president of one of the most important organizations in the country, that is the Society of Indian Law Firms. And since arbitration was referred to, I also chair, you see, the India branch of the Chartered Institute of Arbitrators, which is based in London. Why I have told you all this is that I don't have to give any lecture on this. My idea is to share with the younger people here. I don't have to tell all of you, you are all very experienced people. Here, of course, we have, you see, those who make the laws, we have member of parliament, and those who interpret the law and interpret the constitution. So I don't have to address you. I have to address, you see, the younger people. As I said, I have seen the evolution of this profession. When I started the practice, we had very limited number of matters. Hardly any matters were pending in the Supreme Court. The disposal was very fast. And as Justice Kotiswar Singh has rightly pointed out, today we have 5 crore cases, that is the official figure. So what is the responsibility of the legal profession? I'm not talking of judiciary. They have to look into, you see, their own mindset and all that, how they can dispose of the cases. I told the Honorable Chief Justice of India when we were sharing one platform, he said, we have brought in digitization and everything, technology. And so I told him openly, I say, yes, that facilitates filing of the cases, filing of evidence, so it is good for the litigants. But what about the disposal of the cases? The disposal has to come from here, not from the artificial intelligence. It has to come. So you may have, you see, good technology. It can be used only as an incidental tool, but you can't use it for disposal of the cases. And the same principle I tell the law students. I visit at least 2 law schools every month all over the country at their invitation. I tell them, you can use the technology to do some research and all that, but there can never be a substitute for a law teacher. Law teacher plays, you see, a very important, significant role so far as the development of this profession is concerned. Now, law students, you have so many options available to you. You can join the profession, you can join the litigation side. In litigation, you can do civil litigation, criminal litigation, even corporate litigation. Then on the corporate side, you see, you have the law firms you can join who do all the transactional and corporate work. And it just reminds me that we were talking about the ladies' empowerment in the last session. I can tell you, sir, with daring certainty, being the president of the Society of Indian Law Firms, that in most of the Indian law firms, there is a majority of lady lawyers who are running the law firm. So there is ample scope, you see, for our young lady students who are here, even the other one, to join the law firm. That is another option. And then as Justice from Madras High Court said that there are other options also, legal journalism. That is also open, you see. It's a very, very good field, very innovative field, and we have the online channels here which provide good legal work. Then we have been talking about globalization. Globalization is excellent idea, and legal profession can't remain outside that. If the world's economies, you see, are like merging together to make India, to make world a better place and to provide basic facilities. But I would suggest that there should be glocalization. Glocalization means localization plus globalization. You can't just have globalization while ignoring, you see, the local, the domestic scenarios, the requirements. Therefore, when we talk of globalization, we have to keep in mind our own heritage. As Kotiswar, Honorable Justice Kotiswar Singh pointed out, a long heritage. Father of nation, first Prime Minister, first President, Dr. Ambedkar, Sardar Patel, everyone, you see, they all belong to this profession. Even today, we have, you see, in our parliament, as ministers also, of great eminence who have been lawyers. And therefore, that heritage has to be kept intact. So my appeal to the younger element who are sitting there is, let us keep it as a profession. Don't make it a business, you see. That is very important. But at the same time, there should be mutual cooperation, coordination with entities outside India. I have been president of international organizations also, the Inter-Pacific Bar Association, International Bar Association, UIA. So we have always encouraged mutual cooperation, coordination, mutual exchange of views. With the American Bar Association, we have exchange of delegations going in and you see coming out. And that sort of cooperation is required, even if it is not formalized in the form of any rules. The Bar Council has taken a very good initiative of taking steps to bring the professions of the world together so far India is concerned. Whether it takes a legal form or it does not take, I think the action, the activity, that itself is important. I have had the privilege of meeting, you see, the president of the Law Society of England and Wales repeatedly, many times, and we have been talking of mutual discussion, of mutual cooperation. I have had the privilege of meeting the Lord Chancellor, who was here yesterday also, but I had an exclusive meeting. And he shared our views, you see, that there should be mutual cooperation and all that. Therefore, the emphasis is globalization, yes, but couple it with glocalization. That is the message I want to give. Then there was some discussion about arbitrations and all that. Arbitrations are with great respect, I say, and that is my experience also. Since I chair the Chartered Institute of Arbitration, arbitration has failed to take off in this country. It has definitely failed to take off. It is very expensive. It is very prolonged. It is prolonged. And when we talk, you see, even Justice Kotiswar Singh and Honorable Justice M.R. Shah also said, lawyers should become arbitrators. We have only been talking of judges and lawyers. Why, you see, engineers, architects, why they can't be arbitrators? They can be arbitrators also because there are complex issues which are involved. So it is not just judges and lawyers. I think the technocrats, all those people should also be, and the answer is, to sum up, because I know time constraints, answer is mediation. Honorable Prime Minister said yesterday and I have been echoing it for the last 5-7 years. Mohit Saraf knows about it, my commitment for settlement of disputes. Samjhauta, Prime Minister said we had panchayat system. That was not adversarial. That is the path we have to follow, that try to settle the disputes, you see, and that is a big responsibility on the legal profession, on the law schools, and, sir, to you, that there should be some element, you see, some course of skill development in negotiations, trying to promote settlements of disputes. That is the only answer we have. Thank you very much, sir. Thank you.
Thank you, Dr. Bhasin. I am sorry to the remaining two speakers will have to be brief because we have a deadline which cannot be extended. Others had the privilege, we don't have that privilege. So I'll call upon Mr. Pushkar Shahi. He is an eminent senior advocate of the Patna High Court and he would be standing in for the learned Advocate General Bihar, Mr. P.K. Shahi. Welcome.
Honorable Mr. Justice Ahsanuddin Amanullah, who is chairing the session, other dignitaries, my friends, as I have been told, one has to be very brief, so I'll just speak 2 or 3 lines. And I think that is the evolution of the legal profession is not a recent development, but rather an ongoing journey marked by adaptation and innovation. From the days parchment and quill to the digital age of artificial intelligence, the role and responsibilities of legal professionals have expanded, diversified, and become more complex. My friends have already referred to artificial intelligence, alternative dispute resolution mechanisms, and the pitfalls therein, and what is to be done. So therefore, not repeating it, people are now appearing to be hungry and they have to go for lunch and for the valedictory session. So I can only say that legal profession has never been an easy one. It's for those who are willing to work hard. Contrary to popular belief, excellence and success in this profession does not depend on deceit and trickery. Power of and ability to reason, clarity of expression, analytical prowess, presence of mind, and most important, knowledge of law are the hallmarks of an accomplished professional. Senior members of the bar must discharge their responsibility of adequately training junior and young members both in the skills and ethics of the profession. Being part of a system which is directly connected with regulating human behavior and maintaining order and balance in society, the legal professional has the best opportunity to help maintain orderliness and harmony. While it is important to continue to work towards spreading awareness about fundamental rights amongst the downtrodden, it is about time that we herald the age of duties. The role of the legal professional should not only be to highlight the rights of individuals, but also to emphasize that rights and freedoms do not come without reasonable restrictions. As we look to the future, the legal profession will continue to evolve, remaining an essential pillar of our society and democracy. It is up to lawyers, legal educators, and policymakers to navigate these changes effectively and uphold the principles of justice and equality upon which our legal system is built. Thank you. I could not have been more brief.
Thank you so much, Pushkar, for understanding our predicament and accordingly. And I'm sorry that we could not hear you full. Now I request Mr. Mohit Saraf to just share his views. I would request Mr. Manan Mishra to make up for that loss of time in some other session too. Mr.
Thank you very much. Being a last speaker is always very difficult to speak your mind. But what I'll do is I'll not pick up anything which has been spoken. Yesterday, the Prime Minister, as the head of the government, and also he leads the largest party in the parliament, as a head of legislature, you can say that, he said 2 things which stuck out very clearly. Particularly, what does he expect from legal profession and what does he expect from institution? what he said, which was very, very important, is that he wanted India to be a developed country by 2047. That's what he said. And he wanted legal fraternity, the institution, to support that. That's one important part. The second thing which he said was, and I'm going to just talk about these 2-3 things. The second thing which he talked about was that the law should be simple. I think, Justice, you mentioned that the laws in India have more gray areas than black and white area. I think that's an important part. He said the law need to be understood. Today we lawyers always come up with an opinion which is may. And I think what is very important is the law needs to be enacted properly, it has to be drafted properly, and then obviously the implementation becomes easier and interpretation becomes easier. That's an important part. I think the Chief Justice, the head of judiciary, he said few things which stuck to my mind. And I presented a paper to the Parliament, to the Prime Minister on behalf of FICCI, and he almost echoed the same thing. He says in our constitution, there is separation of power. But he says in a developing country, the 3 wings of the government needs to work together to deliver what Justice Singh said, justice to people. I think that's an important part, and I thought I'll just talk about it a little bit. Now today, if you see the narrative for India, it's a great narrative. Everything is good happening. We are the 5th largest country. We are getting to the 3rd largest country. Our stock market is doing very well. Everything, we have the largest foreign exchange reserves, everything good. And actually, in fact, if you see, in 2000, which is 22 years back, we were a $500 billion economy. Today, we are 3.5 trillion. So we have actually grown 7 times in last 20 years. But if you think about it, Justice Singh said about that the benefit has not come down. He mentioned that, and that's an important part. But if you see the per capita income did only move up by 5 times, not at 10 times. And that is an important thing. And the government really looked at this very closely, how to improve the skill of people, how to make people more productive so that their earnings can improve. And I'm telling you, you'll be a little shocked to hear these numbers, which is very important, and sir, you should hear this number. Today in India, we have 300 million households. 300 million households. Because एक family में 4-5 लोग होते हैं. Today, 200 out of that 300 million household earn less than 5 lakh rupees a month. Whole family, that is 40,000 rupees. 200 million people, 200 million household out of 300 million. And therefore, to deliver goods and to percolate down is a very, very important thing. And if you look at last few years, what has the government done? It's built a lot of infrastructure which helps productivity. Digital connectivity has improved. Everybody's got access to markets, skilling development. A lot of things have happened dramatically. But I would say, really, today, if you look at India, if we really need to grow that 200 million people, sir, what is required is a lot of investment, because money grows money. And the important part, sir, is today, as a lawyers, as judges, we have 2 things which is under our control. One is ease of doing business, and one is enforcement of contract. And I think we should look at it. This is going to change the world if we can get it done. And I'm running it very fast, trying my level best. But if you look at the ease of doing business, we were 143 in 2014. Today we are 63. And largely it is because of the insolvency and bankruptcy law. That thing changed dramatically. And I would say government came up with a law which worked, and then the Supreme Court worked really hard overnight to crystallize the law. And I was working with one of the largest IBC case, ArcelorMittal takeover of SR Steel. And they said, and I asked the GC, I said, are you frustrated that we are litigating so much in India at Supreme Court level? He says, Mohit, this in European Union would have taken 10 years, what your Supreme Court has done. So it's a tremendous amount of work, and this is actually, it's a crazy thing what we have done. But having said that, what is important is what the Prime Minister said, that the law has to be simple, has to be understood, and it has to be clear. And I think that is a very important part why ease of doing business is still not improved enough in India. And that's a big part because laws are poorly drafted, and therefore then the whole burden comes on the judiciary to resolve the interpretation issue. On the enforcement of contract, really this is something which we all do, and I thought that this is an important area we should focus. Out of 190 countries, in 2014, we were 186, bottom 4. In last so many years, we have not improved much. In 2020, we are 163 out of 190. So really, if you look at today, that even if you look at the rule of law, everything is great, the institution is great, but justice is not getting done in India. And this is something which tremendous amount of work is required. If today, if you see, our Indian economy is $3.5 trillion, we expect to be $10 trillion in next 10 years, and which is, I would say, 10 plus 1 or 2 years here. The legal work, the litigation, the arbitration in next 10 years are going to go up by 6 times. Economy will triple, legal work will go 6 times. And today, if our outstanding cases are almost 5 million, 5 crore is the outstanding cases. So imagine what will happen. And therefore, it is required, it is really required that we work on the pendency of case. And I would say again, we always blame judiciary for that, but I think it's not really fair. Judiciary is doing what they can do, but I think there are 3 key pillars who have to be blamed. One is the parliament. Today, if you look at our laws are outdated. Today, even if you are doing intentional breach of a contract, you can only get 73 damages which are reasonable. If that is the case, there is no incentive for people not to litigate. That's a big issue. That is the reason why the backlogs are so much. Today, the interest, the minute you are supposed to pay, whenever the award comes, you should pay interest on the cost of borrowing a corporate from the day it accrues. If that happens, I would say, and the third is the cost. If the courts start awarding actual cost, I would say the backlogs can come down 50%. This is an important thing. On judiciary, we are creating a lot of system, the e-filing and everything to support it. But as Dr. Bhasin said, that people need to be there to make a judgment. And therefore, what is important is we have to disincentivize people to really litigate in India unless they have a real cause. So I would say, to conclude, I would say, for all of us, lawyers and judges, I think the important thing is we need to follow certain ethics in advocacy. We should appeal. We should not take adjournment. We should only appeal when there's a question of law involved. Those type of things are very required if we really need to reduce the backlogs. Otherwise, we can keep blaming judiciary, and they can't do anything because they have to make sure they have to apply mine for every case. Thank you very much.
Before I am held to be in contempt, let me also come here and share. Thank you, Mohit. Just 1 minute, because this is an international conference. I think it is my duty to call upon the participants who have come from abroad to share 1 minute. If anyone of you could just put in a word about all this, where this legal profession and institutions.
introspective but also considered discussion, looking at best practice around the world and considering how this can best be applied in India. Certainly, just what I can say very briefly from a UK perspective is that we have, as our Lord Chancellor pointed out in his speech yesterday, an incredibly open profession. We have made it as open as possible, and it is possible for anyone to come to the UK and practice law without, in many cases, even needing to register. If you want to come to it, for any of those here today, you can come to
plane and you can start providing advice. If you want to re-qualify as a UK lawyer, there is a streamlined, quick and easy process to do so. And what have we found from this? What have we found is that it has helped the UK become an incredible world-leading legal ecosystem where you can get whatever legal advice you want from whatever jurisdiction you want, from something like 200 plus law firms representing 40-something different countries. And that's not only helped us become a legal ecosystem, but also helped the broader economy. It has made business as easy as possible to conduct. It means any international business that wants to set itself up in the UK can seek whatever international law they need whenever they need it. And so what we have found is that the development of the legal sector in London has underpinned the development of the broader economy in London, and therefore the broader success for the United Kingdom. And as a country that cares very deeply about our relationship with India, and that wants to see India thrive, and that wants, from a UK perspective, to have ever-growing bilateral trade and investment with India, this is an aspiration that we hold for India too. And from our perspective, we think that the reforms that are underway have huge potential to help India realise its potential. Because India, as we've been discussing, has phenomenal economic potential, legal potential. It could become the global arbitration hub that Prime Minister Modi mentioned in his, was mentioned before and mentioned yesterday. It could transform, India could be transformed from both a legal and an economic perspective. But to do this, one needs to go and take these first steps. So from a UK perspective, we're excited, but we're excited about the potential that all of these current reforms hold. And we look forward to seeing as they are implemented and as India realises the benefits from looking to the world as well as its huge, enormous domestic talent, and to seeing those two work together to the benefit of India and therefore to the benefit of the world. Thank you.
Thank you so much. I think it's been quite a fruitful discussion, and in the end, just one thought to carry home with. Are we not becoming too professional in the sense that the humanness of the profession is waning away? We are becoming too much digitalized, all dispassionate, unconnected. The legal profession is very different. You have to have connect with the person you represent and the cause which you convey. So I'll just give that, let us not lose track of our main focus of being attached to the person we represent. There has been globalization, lot of pressure, this profession is increasing. But at the same time, you have to understand that we are different from the rest of the profession. We are not professional in the sense of the commercial term of the word professional. And now I was very surprised because one of my senior colleagues, Justice Oak, said that when he went to a national law school, the student said that after finishing law, I'm going to get a startup. He was referring to a firm and he called it startup. So that is the mindset. Let us not go into that. Thank you so much. And Mr. Saurav Chandra Mohapatra would just propose a vote of thanks. Thank you.
Very good afternoon to everybody. Honorable Chair and all the dignitaries on the dais, and my brothers and sisters from the legal fraternity and the law students. Really, I am very impressed on this session because it is a learning for us, all of us, including the students. I thank all the dignitaries who delivered their views, and we learned many things from you. I indebted for that. Again, I thanks all of you. I thanks to all the delegates and the students for their attendance in the session. I also heartily thanks to the chairman and the honorable members of the Bar Council of India arranging this conference. Again, I thanks all of you, sir.